Good morning, good afternoon to our participants in Europe. Welcome to today's discussion on transatlantic digital regulatory governance. My name is Ken Propp, Senior Fellow here at the Atlantic Council's Europe Center and moderator of today's discussion. This is the latest in our series of programs on transatlantic data policy, which is part of our digital marketplace initiative. Over the past several years, the European Union has adopted new digital legislation at a remarkable pace. Most prominent has been a new regulation on competition, Digital Markets Act, another one on platform content, the Digital Services Act, and most recently, a political agreement on an Artificial Intelligence Act. The United Kingdom, following its departure from the European Union, has been active itself legislatively, putting in place a new data protection law, an online safety act dealing with platform content, and it likewise has digital competition legislation in the works. The US Congress, of course, has not acted in any of these areas, but there have been numerous bills introduced, many hearings held, and a lot of intellectual activity. There's also the phenomenon in the United States of state legislators stepping into the void with privacy and platform content laws of their own. As legislation has proliferated in each of these jurisdictions, questions inevitably have arisen about how these separate types of measures will interact with each other, since issues can overlap among them. For example, privacy regulators champion encryption, but use of encryption can protect speech that glorifies terrorism or hate speech more generally. Similarly, age verification, a technique used to shield minors from harmful online content, is seen as intruding upon individual privacy. And to take a third example, pro-competitive steps like promoting greater data portability, greater data access, likewise have implications for privacy. So balancing these competing considerations is a matter for multiple regulators, and the answer that you get may depend upon the regulator that you ask. As a result, structural questions of digital regulatory governance are coming to the fore. How should separate regulators' interactions be organized, in short? Today, we will explore this topic with three speakers: Mark McCarthy of the Brookings Institution and Georgetown University, the author of a new book published by Brookings called Regulating Digital Industries, which proposes a path forward for unified regulation in the United States. Mark will be followed by Kate Jones, Chief Executive of the United Kingdom's Digital Regulatory Cooperation Forum, a governmental body that brings together competition, privacy, and platform content regulators. And in addition, Fran Burwell, Distinguished Fellow here at the Europe Center, who has put forward a proposal for the EU to create a single digital regulatory agency charged with implementation and enforcement. I'll start by posing a few questions to our speakers. Then we will open the floor to questions from our audience. And you can pose these questions through askac.org. First, to Mark. Mark, your new book argues that the US needs a single digital regulator to set detailed competition, privacy, and content moderation rules for companies in specific industries, including search, e-commerce, social media, mobile app infrastructure, and advertising technology. And you give some examples in your book of how these separate sets of rules can generate effects on each other. Could you expand upon the nature of these interactions for us?
Sure, and thanks very much for having me for this discussion. I'm very much looking forward to the conversation. Let me start by saying what I think is the good news, which is that there's large agreement that we do need a regulatory regime for digital industries. We need something that will help promote privacy in that area, that will help vindicate competition as the ideal in that area, and a regulatory structure that would provide for online safety. We haven't quite done that yet in the United States, but I think it's frankly just a matter of time before we get there. These new policies respond to the concentration, the privacy invasions, and the online disinformation that many people have thought are endemic in those industries. So we've gone beyond the question of whether to regulate, and we've really gone to the question of how it's best to do it. And you outlined nicely some of the different measures that have been passed in Europe and the structure that had been developed there. I tend to think that the best way to deal with this new regulatory regime is to house the responsibilities for these new areas of digital competition, privacy, and online safety in a single agency. And my reason really is what you were referring to in your introduction. There's a ubiquitous presence in this field of tensions and synergies among these three policy areas. If these policy areas were as discrete as, say, environmental protection and antitrust, it would be clear that enforcement would go to specialized and separate agencies, and there wouldn't be much need for coordination. But as I see it, these discrete policy areas are not really discrete when you look at them carefully. Protecting privacy, promoting competition, and preserving online safety, those measures almost always reinforce or conflict with each other, or sometimes even both. You mentioned one of the conflicts, the encryption does protect against online invasions of privacy, but by putting their material in an encrypted basis, the companies are blinding themselves to the transmission of child porn and terrorist plans. The Online Safety Act in the United Kingdom calls for Ofcom to figure out whether some system for breaking through encryption is technically feasible. In doing this, Ofcom is required to consult with the privacy officials in the UK, the ICO, but the ICO can only provide opinion and advice. The ultimate decision is in the hands of the ICO alone. And so you have a conflict with a decision maker focused on one aspect or part of the encryption puzzle. Now, sometimes a policy measure can do both. I think data portability is best thought of as something that promotes privacy and competition at the same time. But even here, tensions arise. My interactions with other people on a social media platform, that's information about them. If I can take my information with me when I go somewhere else, what about these other users' rights to prevent that information from being transferred to another provider without their consent? If all you cared about is competition, you might well not be terribly concerned about that. If all you care about is data protection, you might give little weight to the pro-competitive benefits of data portability. Data access is an issue that has many, many forms. Think about advertising. Newspapers would do a much better job of targeting their online ads if they had access to all those profiles of their customers that have been constructed by Google and Facebook. Well, newspapers are in dreadful shape, partly to what many people think is unfair competition from the online companies. Shouldn't the antitrust authorities rescue them by giving them access to this vital advertising resource? Of course, that makes privacy even less present in the online world. We saw the same problem with cookies when Google wanted to get rid of cookies in favor of cohort analysis. Competition authorities were tempted and actually did look at forbidding Google from eliminating cookies because of these anti-competitive effects. interoperability creates issues. It promotes competition that allows users the advantages of these large networks, but also the presence of rival competitive providers. But it makes it harder for social media companies to practice good content moderation. People can plan a disinformation campaign or a harassment campaign on one small network that has lax content standards, and they can launch it with no warning on another platform. So you have these examples of these conflicts and synergies. And they're not just unusual one-off cases that you can sort of dismiss and not pay much attention to. In fact, these policy effects are ubiquitous in the digital world. And that's why I think the best visual model of these policy areas of digital competition, privacy, and online safety is a Venn diagram of intersecting circles where the overlap consumes almost all of the policy space. And now the reason for this ubiquity of these overlaps is what many people have often noticed. That is, data and information is central in these digital industries. Privacy in the digital industries has to do with preventing online companies from collecting too much information. Social media content rules target the way businesses amplify and constrain the spread of information on their systems. And competition policy targets how companies use the data they have collected and analyzed for business purposes. This data is the key economic resource that gives these companies a sometimes insuperable competitive advantage over their rivals. So you've got these systematic intersections, and that is what calls for some sort of institutional reflection of this interdependence. You've got to look at these things holistically rather than as separate independent areas of policymaking. And it seems to me that the UK has gone the farthest of any jurisdiction in recognizing and planning for this. Its Digital Regulatory Cooperation Forum does the job of bringing together the regulators so that they can work in a joined-up way. The defect is that there's no decision-making function in the forum. Decisions rest with the separate agencies. So in the event of disagreement, failure to come to a common position, one agency can simply go its own way. The potential for incoherence and acting at cross purposes seems to me to be self-evident. In the worst case, an agency might prescribe something that another agency forbids, and a business faced with such a conflict would naturally go to court. And so the resolution of these policy conflicts moves from an administrative agency with expertise in a policy area and in an industry to a generalist court with no industry or policy credentials. I'm not actually making a case for the UK to change. I'm much more worried about what the United States would do. And it seems to me the United States, by accident perhaps, is tending to go in the right direction by thinking of the Federal Trade Commission as the chosen vehicle for enforcing privacy, competition, and online safety laws. And that, I think, makes a lot of sense. The FTC already has consumer protection and competition roles, and it's a natural place to put this kind of single regulatory authority. So let me stop there. I'd love to hear people's reactions and comments as the discussion goes forward.
Thank you, Mark. Just one short follow-up question to you. Do you envisage federal legislation as the means for establishing such a structure in the United States, or can this be done short of legislation?
I think that the substantive rules that need to be put into place to actually make a difference in promoting competition, promoting privacy, and protecting online safety, I think those substantive protections have to be done by legislation. We don't really have an effective national privacy law. We don't have the resources we need to do proactive ex-ante promotion of digital competition. And there's no regulatory structure at all for online safety. So that has to be done by regulation. And when it's done, that creates an opportunity for choosing a mechanism for enforcement. And as I said, even though the legislation in the United States didn't make it through the goal line in 2022, each of the bills that proposed those changes named the Federal Trade Commission as the single regulator. And so maybe inadvertently, by accident, the United States seems to be moving towards what I think is the right regulatory structure.
Thank you. Now we're going to turn to Kate. Thank you for joining us from London. We've already heard a bit from Mark already about the unique organization that we had that brings together competition, banking, privacy, and communications agencies, the so-called Digital Regulatory Cooperation Forum. And according to your work plan, your goal is to jointly address complex problems. Could you tell us what in the short term are the areas where the DRCF is concentrating its efforts?
Thank you, Ken. It's an absolute pleasure to be here today, and really interesting to hear Mark's comments, not least because all the examples he gave are exactly the sort of issues that I'm dealing with on a daily basis with my team, as we try to encourage coherence between the digital regulators in the United Kingdom. I thought, if I may, I'd just step back a little bit slightly in explaining very, very briefly the outline of how the UK does its digital regulation before honing in on the DRCF and then on Mark's comments. So, as you may know, in the UK, we have a long-standing approach of setting up statutory frameworks for industry with independent regulators to make the detailed rules, i.e. to regulate for the industries, and then to supervise implementation and enforcement. And what's happened over the last few years is that the government has recognised the need that Mark also eloquently described to have digital regulation. And it's done that through a series of legislation that creates expanded statutory remits for existing regulators. Some of those regulators are sectoral, such as Ofcom that Mark mentioned, which already has responsibility for communications and broadcasting in the UK, and now has responsibility for online safety. And some of those regulators are cross-economy, such as the Competition and Markets Authority on competition issues and consumer protection issues, and also the Information Commissioner's Office on personal data and privacy issues. So, for example, in the UK, the government has recently passed the Online Safety Act, which does indeed give responsibilities to Ofcom for online safety. So particularly for making sure that children don't have access to inappropriate material, and to some extent protecting adults as well, while respecting freedom of expression. We also have the Digital Markets Bill, which is currently going through Parliament, which creates a new ex-ante regime on the competition side for the Competition and Markets Authority to enforce, whereby they will be able to designate businesses or parts of businesses as having strategic market status, and so to impose particular obligations on them. And we also have a data protection and digital information bill that's going through Parliament at the moment, which, amongst other things, tries to expand access to data, for example, for use in AI, while still protecting people's personal privacy. So between these various remits, there is, of course, a need for coherence, just as Mark was outlining. But the UK's approach hasn't been to create a single digital regulator. I think it's, clearly a matter for discretion for each country how it chooses to organise itself. And in the UK, the approach has not been to create one sort of super regulator on the digital side, but instead to harness these expertises of these existing regulators and to give them these additional powers. And it's a necessary flip side of that you have coherence between them, collaboration between them, in order to make sure that the sort of tensions that Mark was talking about don't result in problems. And the regulators in the UK decided themselves, it wasn't a government initiative, they decided themselves 3.5 years ago in 2020 to set up the Digital Regulation Cooperation Forum, which I now lead, which aims to encourage that coherence between the regulators. And actually, I would say so far is pretty effective in doing so, in that every issue that Mark has raised is one that, as I say, we have been addressing and thinking about between us. And I'll give a couple of examples perhaps, and they're really building on what Mark was talking about. One of the first things that the DRCF did was to identify this potential conflict between privacy on the one hand, and then what competition people were saying, that you need to expand access to data in order to ensure open and competitive markets on the other. So the two regulators concerned, the CMA and the ICO, the Information Commissioner's Office in the UK, came together, thought about this, and prepared a public statement that sets out how they see those two sets of obligations fitting together and where actually there are synergies between them, so that nobody could be in any doubt about what was expected in order to comply with the expectations of both the ICO and the CMA at the same time. Or to give another example, when it comes to implementing the new online safety regime in the UK, clearly it's all about how personal data is used, how you know whether somebody is over 18 or under 18 such that they need extra protection, how you or how social media platforms use personal data in their recommender systems. So Ofcom and the Information Commissioner's Office are working really closely together in order to make sure that that Ofcom is implementing the legislation in a way that absolutely has regard to the ICO's principles and legislation. Similarly, other examples, online choice architecture, for example, so harmful practices and recommender systems online. The CMA and the ICO, again, the two of them have been working together, but it's of interest to all four of them to set out very publicly for platforms and for others as to how information and consumer choices are presented online to ensure that consumers' decisions aren't influenced in ways that they're not aware of and might not want. So they've called out behaviours like harmful nudges, sludge practices, biased framing of options, default settings that don't protect privacy, and so on, because it's in the interest of the CMA and the ICO that those are called out and dealt with together. And then another area that I didn't mention because it doesn't involve a bill, but where the British government has been taking lots of action recently, is as regards AI governance. We have an AI white paper in the United Kingdom on which the government has conducted a consultation, and we're shortly expecting the government's formal response to that consultation. But what it sets out is that regulators, the existing sectoral and cross-economy regulators, should have regards to 5 principles, including transparency, explainability, accountability, fairness, and so on, in overseeing the implementation of AI in the industries that they look after. So clearly on AI as well, it's absolutely essential that regulators come together. So our 4 member regulators, which are the 4 biggest in the digital sphere, so the CMA, ICO, Ofcom that I've mentioned, and also the Financial Conduct Authority, that's the 4th one, we have been working together jointly as a foursome to look at the implementation of those principles, to look at how we can promote responsible AI governance in the United Kingdom in a number of different ways. And I'm happy to go into examples in these. Similarly, on horizon scanning, the 4 regulators together have been coming together with the DRCF to say, okay, what's coming up on the regulatory agenda and how do we prepare for it? On quantum, for example, Web3, the metaverse, we have worked together to prepare papers to help the industry think about how they can pursue innovation in those markets while respectful that of the principles that each regulator is trying to ensure remains followed in implementation. Another aspect of what we do as the DRCF, as well as all of this coherence, is actually to be pro-innovation. So in the UK, as I'm sure in the US and indeed in the EU, there's quite a debate. Does regulation hinder innovation or does it assist innovation? As far as we are concerned, as regulators, we see regulation absolutely being about benefiting individuals, but also about promoting innovation too. So as the DRCF, we have come together to create something called the AI and Digital Hub which will launch in 2 or 3 months' time, which gives advice to innovators and businesses on more than one area of regulation at the same time, so that innovators can come to a sort of one-stop shop, get advice on how regulation will operate, and then use that in order to go forward with their business. So we're really trying to set out a pro-innovation approach. Now, I just wanted to, before I wrap up, because I feel I've been talking for a while, I just wanted to comment on a couple of things that Mark talked about. He suggested that if there are disputes in the DRCF, then we will run into difficulties and litigation and so on. I have to say, the DRCF is really well supported by the CEOs and the boards of its 4 member regulators. There is enormous support at every level, therefore, in those organizations for ensuring coherence. Now, that's not to say that each regulator doesn't have a different statutory remit and different things that it has to do. But at the same time, each regulator is absolutely committed to doing that consistently with how its partner regulators are also conducting their remits. Because ultimately, we all have the same ends in view as regards innovation and as regards consumers. So therefore, there haven't been any problems of the type that Mark was referring to. Each regulator does have separate things to do, but we come together, we talk them through, and where there appear to be tensions, such as in the areas we've been talking about, or in encryption and any of those other areas, we talk them through, and we do find that there is a way through those. So for us as the UK, this model is currently working. Just to add, we're really interested in hearing how things are developing in the US and in reaching out to the US and indeed to other jurisdictions as they set up equivalent arrangements. And I'm actually really looking forward to hearing from Fran on the EU as well, because we're quite keen to establish more cooperation with bodies establishing similar sort of cross-regulatory structures in other jurisdictions around the world.
Thank you, Kate. So what you have described to us is a quite elaborate structure for voluntary collaboration among regulators. Mark is suggesting an approach that would concentrate decision-making power in a single body that would have the authority to actually knock heads and come to single resolutions. Wanted to turn now to the European Union. Fran, I mentioned this this elaborate sequence of laws that the EU has adopted. The UK has moved in similar directions on many of these topics as well. Some months ago, you wrote a piece suggesting that the EU needed a data and technology agency with a mandate to ensure implementation of the EU regulations that have recently been adopted. And you suggested that it was not necessarily sufficient to leave these tasks to delegated member state authorities and to the European Commission itself, which is the way things are currently envisaged in the legislation. Could you explain why you think a single overarching agency is needed in the EU?
Sure, thanks very much, Ken. And as you said in the beginning, there is now a huge amount of legislation coming from the EU. And by 2025, 2026, almost all of this will be in force. And much of it will be in force already and will apply over the next year. So we really are on the cusp of a new age of digital regulation in the EU. Each law, whether you're talking about the AI Act, the Digital Services Act, Digital Markets Act, Data Governance, the Data Act, each law is a little bit different. But nevertheless, there are a couple of key issues that I think arise in the way that the EU has set out the implementation and enforcement provisions of these new rules. First, the EU has traditionally relied on the member states to be the implementers and enforcers of its rules. And in many cases, that has been okay. And there were already regulatory bodies in those member states on, for example, food safety and medicines, because those things kind of predated the union. But that's not so much the case in the digital sphere. So I think there's a big question now about whether that relationship with the reliance on the member states is still the way to go. Most of the legislation, with the exception of the Digital Markets Act, calls on the member states to identify a competent authority, a national competent authority to enforce it. In fact, the Digital Governance Act calls for two competent authorities. They could theoretically be the same person or entity. But that's one of the questions, is we don't know, will the member state governments will they call on similar types of organizations and individuals to be the competent authorities across these different legislative areas? Or will they pick a different type for each one? And we don't know. Also, the EU does have a track record in implementing and enforcing digital rules in the name of the General Data Protection Regulation, GDPR, which is run by national authorities who get together in a board. And that's kind of the structure that has been set up for most of these new rules, with some exceptions, which I'll come to in a minute. And what we have seen as a result of GDPR being run by the member state authorities, the data protection supervisors, is differences in the ways that the different member states implement and enforce the rules. This leads to venue shopping by companies, but it also, more importantly, I think, leads to different interpretations. And so that is, I think, going to be a real problem if they continue to decentralize the implementation of the rules. Also, in relying on the member states, that assumes that the member states all have the capabilities to do this. And I think that, particularly when you're talking about the smaller member states, it's a real challenge to do this. And this is not to criticize anyone's good intentions or anything like that, but just finding the right type of technologists who can address all these different rules at a time when the entire union, but particularly the smaller member states, may face labor shortages in this area. There are not a lot of technologists just hanging around waiting for jobs, is going to be a real challenge, particularly for the smaller ones, but I think even the larger ones are going to face this challenge. So this is a recipe for different outcomes in implementing these rules. The second point I want to make is the role of the Commission. In some cases, like AI, although there is a member state level AI coordinator and a board, there's also this new AI office. And we have seen that DG Connect is hiring lots of technologists to be there and to have oversight of these rules and the national structures. DMA is a different box. I think we can talk about that in terms of, because it's competition, and DG Comp has been running competition policy, but this is now ex ante. It's not just a legal thing. And DG Connect is also involved in that. It's a joint thing between these two DGs, which will be interesting to watch. But I think the nub of the problem is that the Commission is inherently a political body. It proposes these legislation. It lobbies Parliament and the member states for the legislation. They probably disagree with that term, but it certainly negotiates in the trilogues. And I find it very hard to see that the Commission would then shift to become a technical, neutral arbiter of these rules. I'm not going to criticize the Commission being political. I think it should be. It's part of the legislative framework. But then it should not be the technical interpreter of the rules. So I think we come to the possibility of an agency. And the AI office, some people in the commission have indicated to me that maybe that's the germ of an agency, but that's only concerned with AI. And I think some of the things that Kate has talked about in terms of the ability to compromise on different bits of overlapping legislation, if you keep that in the commission, it will be a political struggle. But if you can look at it one step removed in a technical space, this is something that an agency can do. An agency is also, I think, better able to recruit and retain a workforce. The commission that is suitable for this. The commission's promotion and it's is aimed at people who are working up the ladder of policy and designing policy, being innovative on policy. It's not necessarily the implementation of rules that have already been agreed. I think also an agency would be perceived as more neutral by external actors such as businesses, but also NGOs. And I think it would also be better able, because it's staffed by technologists, it's looking at reviews of what needs to be done. And I think it's going to be better able to judge whether additional legislation is needed as the technology evolves, or whether there are things that can be done to the existing legislation that would solve this problem. So I think that the way forward is going to be an agency that is somewhat like the EU Food Safety Authority or the Medicines Agency or the Banking Authority, run by technologists, people who are expert in their field, and who can present this as a more neutral field of play, so to speak, than the commission would be able to do. One last point that I wanted to bring up was, since this is transatlantic governance on data regulation, is the US-EU Trade and Technology Council is a place to think about how we can do this together. Not necessarily in a formal way, but to have these conversations. And I would hope we would be able to have them with the UK as well. And I would hope that the EU and the UK would have them, but you can't do it when the decision makers are at 27. That's just too complicated. And so I think that the EU needs to be thinking about an agency. I know it will be complicated. It will be a long, nasty negotiation about even where the agency is headquartered. But I do think that that's the way forward. I'll leave it there.
Thank you, Fran. You actually anticipated a question I was going to ask when you brought up the topic of how these different regulatory structures can be aligned on a transatlantic basis. But before I leave you, I wanted just to come back on this question of the inherent decentralization that the EU has to a significant extent in its regulatory schemes. And you said at the outset that smaller member states were quite likely to actually collapse a variety of these functions into a single existing office of some sort. Is that perhaps not necessarily the worst thing, because it creates a center of gravity in one place? We're also seeing a phenomenon of member states, individual member states beginning to establish these collaborative relationships internally. There was an announcement from France at the end of the year that their data protection authority, the CNIL, and their competition authority were going to collaborate. So, to what extent do you see, in addition to the grand scale suggestion of an agency that you've made, to what extent do you see coherence developing among the member states through impulses like this?
So I think that's entirely possible. I think we will see some states develop quite a good bit of internal coherence, but other states will not. And it is largely going to be up to how does each government decide to organize itself internally. And remember, that could change depending upon the elections within each member state as well. So one thing we're seeing right now in Poland is a big shift in how the different ministries are being run and which regulations are given priority, et cetera, et cetera. Even if you have coherence, however, and I was struck by, in Kate's remarks, I mean, the British have set up a structure which is designed to soften the rough edges between the different regulatory agencies and to try and bring everyone together. It might not work, but I think they've set up a structure where there is every possibility it will work. But even if you were able to do that at a national level, which is a big challenge, what happens if what you're really talking about is 27 different examples of this? And, we now also have to talk about enlargement if we're going to talk about the EU. So down the road, there will be even more. So that's why I think, although, it's important that the member states have a voice in this. And it's important that we build up the technological capability and capacity in each of the member states. But I also think that it's important that those who are subject to the regulations, including companies that are not necessarily headquartered in the EU, have a clear place where they can go and get answers and feel that their voices are heard. And I think that that is best done through a central agency that itself may have ties to the national competent authorities, but where there is a more solidity and more cooperation overall between all the different legislative packages, including eventually the GDPR. So
it brings to mind the great hope of the GDPR, which was for a one-stop shop for companies, but that of course was designating a lead national member state regulator as opposed to a central one. I want to go back to Mark and Kate now to give them an opportunity to react to others' comments, and also if you like to comment on this question of transatlantic connections and how the different structures that are envisaged can connect to each other across the ocean. Mark, you first.
So thanks. I'm impressed with how Fran and I seem to be moving towards centralization and the importance of a single structure for making these kinds of decisions. And I do think given the centrality in the use of information in digital industries, I think tensions and synergies in these policy areas, they're going to be ubiquitous and they're going to be inevitable. To my mind, a common administrative structure provides the opportunity to resolve these in a balanced way. And it's a convenient way to explore some advantageous synergies from complementary policy measures. As Fran points out, the centralization does have the ease of administrative uniformity. Now, can other ways of doing this work? I mean, I think the UK's regime of cooperation and consultation among disparate agencies, it's in a way, it's a very British way of doing things. Let's all get together, and with enough goodwill and attention and willingness to compromise, we can almost always get to a balanced result. And my sense is that because it's in that context of people working together with goodwill and a willingness to compromise, they probably will reach a balanced result almost always. But I sense that a single agency would make the job a lot easier. And for that reason, I think the accidentally holistic approach that the US is taking of selecting the FTC as the nation's digital regulator seems to be the better way to go. It also provides a way of creating a kind of framework for resolving these issues. It seems obvious to me that no priority among the different policy areas should be established. That privacy isn't inherently more important than competition and online safety and vice versa. Some legislation in the United States sort of made that mistake by treating competition as a kind of constitutional value and privacy as a subservient business interest. So I don't think you can do things that way. You've got to have a case-by-case approach. And I think everyone should agree that some kind of cost effectiveness where you don't interfere with each other's policy goals any more than absolutely necessary. You've got a standard that's very much like the constitutional standard in the US and the necessity and proportionality test in the European Union. You want to interfere in the least possible way. But beyond that, I think you're going to have judgments based on a rough estimate of benefits and costs. How much privacy will be lost? How much gain will there be in competitive vibrancy? And I think an institutional structure where those kind of questions can be debated and thought through, and a kind of tradition of how to approach them, it might be easier to do within a common administrative structure. And so for that reason, I still think it's a better way to go. In terms of transatlantic, I do think in this area of institutional structure, I'm a strong believer in letting each country go its own way. I know it would be nice if there were one agency where we could all get together and three different people could sit together and solve the problem. But I do think the benefits of letting institutional experimentation are much greater. And so I wouldn't want to push for institutional uniformity. I think what I'm pushing for is what I think works best for the United States, but I wouldn't want to make a sort of foreign policy issue out of making everyone move in the same direction.
Dave.
Thank you. I think there's an awful lot of good sense spoken by both Fran and Mark. It's been very interesting to hear what they say. As regards the EU, clearly there is a very complex game of three-dimensional chess to be played in trying to work out now who has responsibility for what and how it goes forward, because there's been this wealth of legislation and, as Fran described, a wealth of potential new agencies at domestic level, as well as then EU oversight, and how those fit together as between the EU and member states, and then as between one remit and another, is a really very, very complex question. And clearly some sort of solution and way forward is going to have to be found to that, whether it's the one that Fran is proposing or another one. And as regards the US, I think it's very, very interesting to hear what Mark is outlining. If I think about this from the perspective of businesses for a second, I can see that as far as businesses are concerned, the more simple regimes are and the more harmonization there is, the easier that then is likely to be for companies who are operating across jurisdictions. And I can understand absolutely why Mark is saying that one agency in the US is a good idea. In the UK, I don't think it would be a good idea at this time. That's partly because we are starting from very different places in terms of the independent regulators that we already have, responsible for different statutory remits, as I've outlined, but also many other regulators in the UK that have responsibility for sectors that are increasingly touched by digital developments. So, for example, our health regulators, our legal regulators, and so on, in all sorts of different areas. The challenge in the UK is that if you create one digital agency, there then becomes a challenge with how that interacts with those other regulators when they are managing aspects of the digital agenda. So if you're thinking about uses of AI in healthcare, would that then go to your digital agency, or would it remain with your healthcare regulator, and so on? So by having a sector-specific approach, you maintain the flexibility for regulators to each operate in their own areas of expertise while coming together on common issues. That also gives you quite a bit of flexibility for the future. In the UK, as I think in the EU and elsewhere, we're moving towards a much more risk-based approach to regulation, creation of more open-ended obligations for companies where they have to protect their consumers and protect other individuals from harms. And that goes hand in hand then with a sense that regulatory remits are going to evolve over time. And again, by keeping the specialism of individual agencies rather than a central digital agency, you allow for that evolution. For example, you allow our Financial Conduct Authority to oversee the implementation of the new consumer duty in that area, using their many years of expertise in the financial sector. If you change in the UK to a central digital agency, you risk losing some of that expertise along the way, or duplicating it, or creating a more complicated structure. So the UK structure works for us, but at the same time, very open to different arrangements elsewhere. I think what's important is that there are arrangements rather than what they look like. And also, as I mentioned earlier, very open to having dialogue with the EU, US, and others. And just to say, if people listening in are interested in what we're doing in the UK, our website is drcf.org.uk. And we're interested in hearing from people who might be thinking about regulatory cooperation arrangements. This, as I say, is what takes up my time. It's very interesting to hear from Mark and Fran, and we'd be glad to hear from others thinking in this area as well.
Well, speaking of interaction with the audience, I wanted to bring in a question now for Mark McCarthy, and the question has to do with the CIRCIA legislation, CIA legislation. I don't actually know what that acronym stands for. Moving the U.S. towards a unitary rulemaking approach on incident reporting, and whether an initiative like that is an example of a possible model for addressing data security and privacy issues in a more holistic way.
I'm afraid I'm going to have to plead ignorance to the legislation that the person is referring to, I mean, I'm happy to go off and talk about something else, but that I really don't have anything to comment on that particular proposal.
Okay, let me just come back to you with another question then. You know, Kate has suggested that it's hard to unscramble the omelet when you already have regulatory agencies with their own statutory remits, and those remits are constantly being expanded to deal with new issues like AI. I don't understand what you're proposing to be necessarily inconsistent with that, because we actually have the same phenomenon here in the United States, where you have financial regulators, for example, involved in overseeing the introduction of AI into their products. And in fact, the new U.S. executive order goes some way in that direction too. Is that a correct observation? Are these two approaches that can sit together with each other?
Yeah, I think you're pointing to the presence of lots of independent agencies in the U.S. structure. So in that way, we're very similar to the UK. But the digital agency that I'm thinking of would not be sort of since digital is everywhere, it wouldn't be the regulator of everybody. It's confined. You'd name the industries that you'd be supervising. My list is search, social media, electronic marketplaces, app stores, maybe ad technology. And then you confine the agency further to just 3 policy areas of privacy, competition, and content moderation. And so you have something that looks in many respects like a sector-specific agency, something that looks more like the Federal Communications Commission than an economy-wide general purpose regulator. And so if I really had my ideal, and I did it the way I could write the bill and make it happen all by myself, I'd set up a brand new digital regulator as a sector-specific agency focused on those industries and those policy areas. And I think putting it in the hands of the Federal Trade Commission is a reasonable compromise to get you there. But once that agency is set up, it doesn't spread all over the entire economy. It's confined to just those 5 industries and those 3 policy areas. And so it really is discrete. It does raise a question about artificial intelligence, and many people have thought if you're for a digital agency, then you must mean that the digital agency should handle artificial intelligence issues. And the way I think of it, that's not the case at all. There may be a need for an artificial intelligence agency. These foundation models and frontier models look like they have capacities that have to be tested and controlled and looked at for safety at the model level. And you might need an agency, maybe in the United States it could be NIST, to look over the processes and procedures that developers are using when they develop those models and then put them into effect. But the real regulation of AI is going to be AI as used. And we have a very healthy regulatory system already set up to take care of that. As Lena Khan said, there's no exemption from the consumer protection laws for artificial intelligence. If you've got a problem with discrimination using artificial intelligence, you can't say to the Equal Employment Opportunity Commission, hey, I was using artificial intelligence. The law doesn't apply to me. So I think you can go a long way towards regulating artificial intelligence as used. And that's not the responsibility of the digital regulator. That's the responsibility of the Equal Employment Opportunity Commission or the financial regulators, whoever happens to be involved. If you need a special artificial intelligence agency, I'd set it up as a kind of adjunct to NIST. And I wouldn't put it in the digital regulator, which is concerned solely with competition, privacy, and content moderation in these 5 discrete areas of search, electronic commerce, electronic marketplaces, app stores, and ad tech.
Thank you, Mark. Well, we've come to the end of the hour. This has been quite a wide-ranging conceptual discussion on a set of issues that is continuing to evolve and are often very contentious. So hopefully we have stepped back and seen a bit of the forest rather than just focusing on the trees. I'd like to thank each of our speakers for joining us this morning. Thanks to our audience, and just to mention that this discussion this morning is part of continuing work that the Atlantic Council of Europe Center does on transatlantic digital policy topics through our events and publications. And you can follow us on Twitter at AC Europa. Thank you all for joining, and goodbye.